Good afternoon, Sir Bernardo Masangkay. Good afternoon, fellow classmates. I, together with my co-presenters, will report about the Chapter 3, Dissolution and Winding Up. Next. Article 1828. The dissolution of a partnership is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on as distinguished from the winding of the business. So next. So before I proceed in my real topic, let us first define the words that are needed to be defined so we can understand all what we are going to talk about. So when we say dissolution, it is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on of the business. It is at this time that the partners stop operating the business together. It also symbolizes the dissolution of a partnership. Another word is winding up. It only means that it is the process of settling the business or partnership affairs after the dissolution. Lastly is the termination. It's that point in time where all the partnership affairs completely wound up and finally settled. It also denotes the end of the relationship's existence. Next. Article 1829. On dissolution, the partnership is not terminated but continues until the winding up of a partnership affairs is completed. Next is partnership not terminated by dissolution. It also says that a partnership's dissolution should not be interpreted as its extinction. So the principal significance of dissolution is that thereafter, no new partnership business should be undertaken, but affairs should be liquidated and distribution made to those entitled to the partners interested. In additional, up until the winding up is finished, the partnership remains in effect. Dissolution then refers to a change in the nature of the partnership relationship rather than the actual closure of the partnership's operations. And of course, the solution of a partnership must also be distinguished from a mere suspension in the conduct of its business or its operations. Next. So in Article 1813, dissolution is caused, number one, without violation of the agreement between the partners. And then in this number, it has a specific topic, letter A, by the termination of the definite term or particular undertaking specified in the agreement. Letter B, by the express will of any partner who must act in good faith when no definite term or particular undertaking is specified. And then letter C, by the express will of all the partners who have not assigned their interests or suffered them to be charged for their separate debts either before or after the termination of any specified term or particular undertaking. And lastly, by the expulsion of any partner from the business bona fide in accordance with such power conferred by the agreement between the partners. Next slide. Number two, in contravention of the agreement between the partners, or what we called by the express decision of any partner at any moment, where the circumstances do not permit a dissolution under any other provision of this article. Number three, by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. Number four, when a specific thing which a partner had promised to contribute to the partnership perishes before the delivery, in any case by the loss of the things. However, the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership, where the partner who contributed it, having reserved the ownership therein, has only transferred to the partnership use or enjoyment of the same. So number five, by the death of any partner. Number six, by the insolvency of any partner of the partnership. Number seven, by the civil interdiction of any partner. And lastly, by the decree of court under the following article. So next slide. Causes of dissolution. So it outlines the statutory grounds for dissolution in Articles 1830 and 1831. So thereafter, further causes listed in Article 1840. So number one, without violation of the agreement between the partners. So it basically means that it should be emphasized that dissolution can occur both in compliance with and in breach of the partner's agreement. Number two, voluntary or involuntary. So it may be voluntary when brought about by the will of one partner, more than one partner, or all of the partners, or it may be involuntary when brought by an outside force or the operation of law. Number three, extrajudicially or judicially. So a court order or an judicial method can also be used to dissolve a partnership. And lastly, automatic dissolution. So it will also be noted that the partnership dissolves automatically for the reasons listed in Article 1830. So it has also been said that upon the dissolution of a partnership, the original partners may create a new partnership to carry on the business under the same conditions. Next. Dissolution effected without violation of partnership agreement. So there are four ways by which a partnership may be dissolved without violation of the partnership agreement. So first, termination of the definite term or particular undertaking. So it basically indicates that a partnership may be formed for a set period of time or with a specific endeavor as its aim. After the expiration of the term or particular undertaking, it also says that the partnership is automatically dissolved without the partners extending the said term or continuing the undertaking. So number two, by the express will of any partner. So this indicates naman that as long as the partner in question acts in good faith, a partnership at will may be dissolved at any moment by any partner without the approval of his co-partners and without the breach of contract. So each partner has the authority and the right to end the partnership at any time in this form. So number three, by the express will of all the partners. So in these third ways, there must be unanimous consent to dissolve the partnership before the end of a specific period of the particular endeavor. So it further clarifies that the partnership cannot be ended by the majority acting alone without violating the contract. So lastly, by the expulsion of any partner. So the expulsion must be in good faith and in accordance with the authority granted by the partnership agreement between the partners. However, the partner expelled in bad faith can claim damages. Next, dissolution effected in contravention of partnership agreement. So first is dissolution may be for any cause or reason. It indicates that even though the partnership was formed for a specific term or specific project, any partner may dissolve the partnership at any moment without the approval of his or her co-partners at his or her sole discretion or for any reason. Number two, power of dissolution always exists. So the delectus personae theory gives a partner the authority, but not always the right, to end a partnership even if his fellow partners want to keep the company going. Number three, legal effects of dissolution. So in the event of an unauthorized dissolution, the withdrawing partner is liable naman for damages. Next. Business becomes unlawful. So dissolution may be caused involuntarily when a supervening event makes the business itself of the partnership unlawful or makes it unlawful for the partners to carry it on together. And a partnership must have a lawful object or what we call a purpose. So next, loss of a specific thing. So this provision of Article 1830 refers only to specific things. First, loss before delivery. So if the specific thing to be contributed by a partner is lost before the delivery, the partnership is dissolved because there is no contribution in as much as the thing to be contributed cannot be substituted with another. Number two, loss after delivery. If the loss occurred after the delivery of the thing promised, then the partnership is not dissolved. Number three, loss where only use or enjoyment contributed. So if only the use or enjoyment of the thing is contributed, the partner having reserved the ownership thereof, the loss of the same before or after the delivery dissolves the partnership. Next, death of any partner. So it says that the deceased partner ceases to be associated in the carrying of the business. Consequently, his passing caused the partnership to dissolve. So according to this clause, the surviving partners are only permitted to carry on with the company as far as is required to wind it up. So insolvency of any partner or of a partnership. Number one, if a partner is insolvent, his interest in the partnership is subject to the right of his creditors. And if the partnership's assets have been exhausted, he is unable to fulfill his duties to the partnership's creditors. So an insolvent partner has no authority to act for neither the partnership nor the other partners to act for him. Number two, the insolvency of the partnership renders its property in the hands of the partners liable for the satisfaction of partnership obligations. That is making it impossible for them to keep the business going, which effectively amounts to dissolution. Next, civil inter civil interdiction of any partner. Can we go back to that slide? Civil interdiction of any partner. So a partnership requires the capacity of the partners. A convicted person suffering from the accessory penalty of civil interdiction cannot give consent at his capacity to act is limited thereby. So according to the law, civil interdiction denies the person serving a sentence the liability to manage his property and dispose of it by any act or conveyance that would take effect during the person's lifetime. So may I call on the next reporter?
Article 1831. On application by or for a partner, the court shall decree a dissolution whenever: Number 1. A partner has been declared insane in any judicial proceeding or is shown to be of an unsound mind. Number 2. A partner becomes in other way incapable of performing his part of the partnership contract. Number 3. A partner has been guilty of such conduct as tends to affect prejudicially the carrying of the business. Number 4, a partner willfully or persistently commits breach of the partnership agreement or otherwise so conducts himself matters relating to the partnership. To the partnership business that is not reasonably practicable to carry on the business on partnership with him. Number 5, the business of the partnership can only be carried on at a loss. And number 6, other circumstances render a dissolution equitable. Next. Under Article 1813 or 1814, number 1, after the termination of the specific term or particular undertaking. Number 2, at any time in the partnership was a partnership at will when the interest was assigned or when the charging order was issued. Grounds for dissolution by decree of court. There are many situations or events that may constitute a valid reason for dissolving a partnership, but which are subject to dispute or difference of opinion to make a judicial dissolution necessary. Dissolution of a partnership may be ordered judicially after a hearing on application either by a partner in the cases mentioned in paragraph number 1, numbers 1 to 6, or by the purchaser or assignee of a partner's interest under paragraph 2, numbers 1 and 2. Next. Number 1, on application by a partner, letter A, insanity. The partner may have been previously declared insane in a judicial proceeding. Otherwise, the fact of his being unsound mind must be duly proved. Letter B, incapacity. The incapacity must be one which affects the ability of a partner to perform his duties as a partner. For example, brain dead or comatose, it means he can't perform his duties to the partnership. Letter C, misconduct and persistent breach of partnership agreement. Like incapacity, conduct prejudicial to the carrying on the business and persistent breach of the partnership agreement are grounds for judicial dissolution. If ever one partner is acting of misconduct and the other partner is asking him to leave but he doesn't want to leave, the court can intervene. Letter D, business can be carried on only at a loss. Main purpose of the partnership is to generate profit. It may be dissolved by decree of court when it becomes apparent that the business is unprofitable with no reasonable prospects of success. Lastly, other circumstances about the business, fraud in the management of the business, refusal without justifiable cause to render accounting of partnership affairs. Number two, on application by a purchaser of a partner's interest. After the termination of the specified term or particular undertaking, and at any time if the partnership was a partnership at will when the interest was assigned or when the charging order was issued, there are two examples. Example number one, under Article 1813, A and A, B, and C formed a partnership to continue for a term of 5 years. On the third year, C sold his entire interest to D. Such conveyance does not dissolve the partnership, and D does not become a partner, his only right being to receive the profits to which C would otherwise be entitled. Hence, D cannot ask for judicial dissolution of the partnership. However, if after the fifth year, the partnership is continued, D is entitled to ask for judicial dissolution. The partnership, as continued, may or may not be a partnership at will. Example number two, suppose now of the fifth year, the partnership was continued by the partners without any express agreement, becoming a partnership at will. If C's interest was purchased by D or a charging order was issued by a court against C in favor of D, is judgment creditor as provided in Article 1814 when the partnership was already a partnership at will, D at any time may ask for judicial dissolution. And take note that the rule in Article 1831 applies if in continuing the business a partnership at will is created or the partnership is a partnership at will from the beginning. Next. Article 1832, except so far as may be necessary to wind up partnership affairs or to complete transactions begun but not then finished. Dissolution terminates all authority of any partner to act for the partnership. Number one, letter A, with respect to the partners. When the dissolution is not by the act, insolvency, or death of a partner. Letter B, with respect to persons not partners as declared in Article 1834. When the dissolution is such act, insolvency, or death of a partner in cases where Article 1833 so requires. Next. Effects of dissolution on authority. Number one, general rule. Unless otherwise stipulated, every partner considered the agent of the partnership with authority to bind the partnership as well as the other partners with respect to the transaction of its business. Upon dissolution, the partnership ceases to be a going concern and the partner's power of representation is confined only to acts incident to winding up or completing transactions begun but not then finished, and only the contracts entered into before the dissolution will be terminated. Number two, qualifications to the rule. The foregoing, however, is a general rule that is subject to the qualifications set for in Articles 1833 and 1834 in relation to Article 1832. Letter A, insofar as the partners themselves are concerned, contract is immediately terminated when the dissolution is not by the act, insolvency, or death of a partner. When the dissolution is caused by those, termination of authority depends upon whether or not the partner had knowledge or notice of the dissolution as provided in Article 1833. Number 2, with respect to third persons, partnership is generally bound by the new contract, although that authority of the acting partner as it affects his co-partners is already deemed terminated under Article 1832 and 1833. For example, A, B, and C were partners in X and Company. The term of existence of the partnership as fixed in the articles of partnership expired yesterday. Therefore, it was dissolved. Here, the dissolution was caused not by the act, insolvency, or death of a partner. If today A enters into a new transaction with D, A alone assumes whatever liability may arise under the contract because his authority to act for the partnership, X and Company, as to bind B and C, terminated as of yesterday when the partnership was dissolved. If the partnership is liable to D under Article 1834, B and C are entitled to indemnity from A. Next. Article 1833. Where the dissolution is caused by the act, death, or insolvency of a partner, each partner is liable to his co-partners for his share of any liability created by any partner acting for the partnership as if the partnership had not been dissolved unless, number 1, the dissolution being by act of any partner. The partner acting for the partnership had knowledge of the dissolution. Number 2, the dissolution being by death or insolvency of a partner. Right of a partner to contribution from co-partners. The above article speaks of dissolution caused by the act, insolvency, or death of a partner. Where a partner enters into a new contract with a third person after dissolution, the new contracts generally will bind the partners, and each of them is liable for his share of and liability created by the acting partner as if the partnership had not been dissolved. Authority of partners as among themselves to act for the partnership. And there are two instances, namely, the cause of the dissolution is the act of a partner and the acting partner had knowledge of such dissolution. If he has knowledge, the partnership will not bind. It will cause a bad faith if the acting partner knows that the partnership is in the process of wind up and he still enter into a new partner. And it is designed to protect the remaining partner who might continue to act from the partnership as a going concern without the knowledge of the dissolution. Number 2, the cause of the dissolution is the death or insolvency of a partner, and the acting partner had knowledge or notice of the death or insolvency. If he has knowledge and notice, the partnership will not bind. Discards the fiction that everybody is presumed to have a knowledge of death and insolvency. Next. Next slide. Pabalik dun sa kabila dun. Yan. When a partner has knowledge or notice of a fact. The Uniforms Partnership Act defines the two terms as follows. Number 1, a partner has knowledge of a fact. When a partner has knowledge or notice of a fact, knowledge of fact, he has knowledge of such other facts as in the circumstances showed bad faith. Number two, a person has notice of a fact. Notice of fact states that the fact to such and delivers through the mail. For examples, A, B, and C were partners. A informed B that the former was resigning from the partnership. The partnership was dissolved by the act of A. C had no knowledge of the dissolution if partnership liability is incurred by a contract entered into by C. Then A and B are bound to contribute their share of the liability as if the partnership had not been dissolved. Hence, A and C can be called upon to contribute their share in the liability. And lastly, if A had died or had become insolvent, knowledge or notice on the part of B will justify non-liability on the part of the other partners. Next reporter.
So, in Article 1834, after dissolution, a partner can bind the partnership except as provided in the third paragraph of this article. So, the first one is by an act appropriate for winding up partnership affairs or completing transactions and finish at dissolution. And the second one is by any transaction which would bind the partnership if dissolution had not taken place provided the other party to the transaction. It had extended credit to the partnership prior to dissolution and had no knowledge or notice of the dissolution or true he had not so extended credit had nevertheless known of the partnership prior to dissolution and having no knowledge or notice of dissolution. The fact of dissolution had not been advertised in a newspaper of general circulation in the place or in each place if more than one at which the partnership was regularly carried on. Next. So, the liability of a partner under the first paragraph number 2 shall be satisfied out of partnership assets alone when such partner had been prior to dissolution. The first one is unknown as a partner to the person with whom the contract is made, and so far unknown and inactive in partnership affairs that the business reputation of the partnership could not be said to have been in any degree due to his connection with it. Next. So, the partnership is in no case bound by any act of a partner after dissolution, where the partnership is dissolved because it is unlawful to carry on the business, unless the act is appropriate for winding up partnership affairs, or where the partner has become insolvent, or where the partner had no authority to wind up partnership affairs, except by a transaction with one or had extended credit to the partnership prior to dissolution and had no knowledge or notice of his want of authority, or had not extended credit to the partnership prior to dissolution and having no knowledge or notice of his want of authority, has not been advertised in the manner provided for advertising the fact of dissolution in the first paragraph. Nothing in this article shall affect the liability under Article 1825 of any person who after dissolution represents himself or consent to add another representing him as a partner in a partnership engaged carrying on business. Next. Power of partner to bind dissolved partnership to third person. Article 1834 enumerates the cases when a partner continues to bind the partnership even after dissolution and the cases when he cannot bind the partnership after dissolution. Upon the dissolution of the partnership as between themselves, the power of one partner to act and bind the others is effectively terminated according to Article 1832 to 1833. But the authority of a partner may apparently continue as regards third persons who subsequently extend credit on the assumption that the partnership is still existing. Since a partnership once established is, in the absence of anything to indicate its termination, presumed to exist, the law for the protection of innocent third person imposes upon partners the duty of giving notice of the dissolution of the partnership. For example, where A, B, and C are active and ostensible partners, A's retirement terminates the actual authority of A, B, or C to impose new obligations on the partnership, except such as may be necessary to wind up the business or to complete transactions begun not then finished. Assume that D has extended credit to the partnership prior to A's retirement and has no knowledge of A's retirement, and that no notice thereof has been communicated to D by mail or otherwise then on the ground of estoppel. Next. So here's the notice of dissolution creditors. The first one is as to person who extended credit to partnership prior to dissolution. Customers of the partnership or persons who extended credit to the partnership prior to its dissolution must have knowledge or notice of the dissolution to relieve the partnership from liability. The second one is as to persons who had known of partnership existence. Persons who had not so extended credit prior to its dissolution but who had known of its existence, the fact that the dissolution had been published in the newspaper would be sufficient. And the third one is where active partnership has no authority to wind up partnership affairs. Under the third paragraph, notice of dissolution is unnecessary except in case number 3, where the partner has no authority to wind up partnership affairs. Third persons dealing with the partner without such authority are protected under the same circumstances mentioned in paragraph number 1. And the last one is where acting partner has become insolvent. As to insolvency, law makes a distinction between the right of a partner who has no knowledge or notice of the other's partner insolvency to bind the partnership and the right of a third person to claim that his contract with the partnership is valid, notwithstanding its dissolution through insolvency of the partner with whom the contract was made. The former is recognized under Article 1833 while the latter is denied under Article 1834, said that innocent partner is protected in his continued right to make binding partnership agreements, but no similar protection is extended to a party who innocently makes a contract with an insolvent partner. Next. So the next one is character of notice required. The first one is as to prior dealers. Furthermore, there is no duty on the part of a prior dealer to inquire into the question of retirement, even though the prior dealer has the means of obtaining knowledge of such retirement but failed to make use of it. A prior or former dealer is one who has extended credit on the faith of the partnership through confidence in the solvency and probity of the firm. And then the second one is the as to all others. Notice is accomplished by an advertisement in a local newspaper. Actual notification is not necessary. It should be noted, however, that the requirement of newspaper notice appears to exist only where the third party knew of the partnership prior to dissolution. If he did not, he is entitled to no notice or whatsoever. For example, T purchased goods from a partnership. Thereafter, the partnership was dissolved. Notice of the dissolution was advertised in the local newspaper. Without knowledge of the dissolution, T thereafter extended credit to the supposed partnership at the request of one of its members in connection with a transaction not necessary for the liquidation of the business. May T hold the partnership liable on the transaction? The answer is no, because prior dealers must be given actual notice of the dissolution of a partnership in order to prevent the continuance of partnership liability. T, however, is not a prior dealer. Hence, he is considered to have received notice as a matter of law when the fact of dissolution was advertised in the local newspaper. Next. So, dormant partner need not give notice. Under the second paragraph, the liability of a partner unknown as such to the person with whom the contract is made or so far unknown and inactive in partnership affairs shall be satisfied out of partnership asset alone. This is qualification of the rule that partners are liable pro rata with all their property after the assets of the partnership had been exhausted for partnership obligation. This is under Article 1816. And then the next one is Article 1835. The dissolution of the partnership does not of itself discharge the existing liability of any partner. A partner is discharged from any existing liability upon the dissolution of the partnership by an agreement to that effect between himself, the partnership creditor, and the person or partnership continuing the business. And such agreement may be inferred from the course of dealing between the creditor having knowledge of the dissolution and the person or partnership continuing the business. The individual property of a deceased partner shall be liable for all obligations of the partnership incurred while he was a partner, but subject to the prior payment of his separate debts. Next. So, the effect of dissolution on partners' existing liability. The dissolution of a partner does not of itself discharge the existing liability of a partner. A partner may be relieved from all existing liabilities upon dissolution only by an agreement to that effect between himself, the partnership creditor, and the other partners. Then the next one is liability of state of deceased partner. In accordance with Article 1816, the individual property of a deceased partner shall be liable for all obligations of the partnership incurred while he was a partner. Note that individual creditors of the deceased partner are to be preferred over partnership creditors with respect to the separate property of said deceased partner. For example, if A, B, and C are partners and A retires, all three, A as well as B and C, continue to be personally liable for any partnership debts existing at the time of A's retirement. Similarly, if A dies, his individual estate is available to partnership creditors, subject, however, to the claims of A's personal creditors. Even an agreement among A, B, and C, whereby B and C promise to assume the partnership debts does not release A, unless the creditors assent to such substitution of debtors either by express agreement or by agreement inferable from the course of dealing. Next. Manner of winding up. The winding up of the dissolved partnership may be done either judicially under the control and direction of the proper court upon cause shown by any partner, his legal representative, or his assignee, or extrajudicially by the partners themselves without intervention of the court. So the next one is persons authorized to wind up. Person designated by the agreement. And the second one is if no agreement, all partners who have not wrongfully dissolved the partnership. And the third one is legal representative of the last deceased partner, when all the partners are already dead and not insolvent. If there is remaining partners, they are the one who is responsible in winding up the business, not the legal representative of the deceased partner, unless the deceased is the last surviving partner. The deceased partner's estate is not liable for any subsequent debts or losses incurred by the surviving partners who continued the partnership business without the consent of the state. May I call on next reporter?
Next, Article 1837. When dissolution is caused in any way, expect in contravention of the partnership agreement each partner, as against his co-partners and all persons claiming through them in respect of their interest in the partnership, unless otherwise agreed. The partnership property applied to discharge its liabilities, and the surplus applied to pay in cash the net amount owing to the respective partners. And if dissolution is caused by expulsion of a partner, bona fide under the partnership agreement, and if the expelled partner is discharged from all partnership liabilities. either by payment or agreement under the second paragraph of Article 1835, he shall receive in cash only the net amount due him from the partnership. If dissolution is caused in contravention of the partnership agreement, the partner should have the rights to damages for breach of the agreement. The partners who have not caused the dissolution wrongfully, if they all desire to continue the business in the same name either by themselves or jointly with others, during the agreed term for the partnership and for the purpose, they secure the payment by bond approved by the court or pay to any partner who has caused the dissolution wrongfully. Next, right of partner to application of partnership property on dissolution. The right of the partners to have partnership property applied to discharge partnership liabilities and the surplus, if any, distributed in cash to the respective partners depends on whether the dissolution is caused without violation of the partnership agreement or in violation of the partnership agreement. Next, rights were dissolution not in contravention of agreement. First, to have the partnership property applied to discharge the liabilities of the partnership, and to have the surplus, if any, applied to pay in cash the net amount to respective partners. When the dissolution is caused by expulsion of a partner, bona fides such expelled partner may be discharged from all partnership liabilities, either by payment or by an agreement between him, the partnership creditors, and the other partners in Article 1835. He shall have the right only to receive in cash the next amount due him from the partnership, and if dissolution is proper or rightful, no partner is liable for any loss sustained as a result of the dissolution. Next, rights for dissolution and contravention of agreement. Number 1. Right of the partner who has not caused the dissolution wrongfully. When the partnership is dissolved in violation of the partnership agreement, the rights of a partner vary depending upon whether he is the innocent or the guilty partner. To have partnership property applied for the payment of its liabilities and to receive in the cash his share of the surplus. Next, to be indemnified for damages caused by the partner guilty of wrongful dissolution. Next, to continue the business in the same name during the agreed term of the partnership by themselves or jointly with others. And last, to possess the partnership property should they decide to continue the business. Next, rights of partner who wrongfully caused the dissolution. If the business is not continued by the other partners, it is to have the partnership property applied to discharge its liabilities and to receive in cash his share of the surplus less damages caused by his wrongful dissolution. And if the business is continued by the other partners, it is to have the value of this interest in the partnership at the time of the dissolution ascertained and paid in cash or secured by bond approved by court. Next. Next, Article 1838, where a partnership contract is rescinded on the ground of the fraud or misrepresentation of one party thereto, the party entitled to rescind is, without prejudice to any other right. Number 1, to a lien on or right of retention. The surplus of the partnership property after satisfying the partnership liabilities to third person for any sum of money paid by him, for the purchase of an interest in the partnership, and for any capital of advances contributed by him. Next, to stand. After all liabilities to third persons have been satisfied, in the place of the creditors of the partnership for any payments made by him in respect of the partnership liabilities, and last, to be indemnified. To be indemnified by the person guilty of the fraud or making the representation against all debts and liabilities of the partnership. Right of partner to rescind contract of partnership. If one is included by fraud or misrepresentation to become a partner, the contract is voidable or annullable in Article 1390. And if the contract is annulled, the injured partner is entitled to restitution under Article 1398. However, until the partnership contract is annulled by proper action in court, the partnership relations exist under Article 1390, and the defrauded partner is liable for all obligations to third persons. Next, right of injured partner where partnership contract rescinded. This article speaks of the rights of the injured partner where the partnership contract is rescinded on the ground of fraud or misrepresentation. Number 1, right of a lien on or retention of the surplus of partnership property after satisfying partnership liabilities for any sum of money paid or contributed by him. Number 2, right to subrogation in place of partnership creditors after payments of partnership liabilities. And next, right of indemnification by the guilty partner against all debts and liabilities of the partnership. It is to be noted that the right of the partner entitled to rescind or without prejudice to any other rights under other provisions of law. Next, Article 1839. In settling accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary. First, the assets of the partnership, and the assets of the partnerships are the partnership property and the contributions of the partners necessary for the payment of all the liabilities. Next, the liabilities of the partnership. Those owing to creditors other than partners, and next is those owing to the partners other than for capital and profits, and those owing to partners in respect of capital, and last those owing to partners in respect of profits. Next, liquidation and distribution of assets or of the sole partnership. The process of winding up where the business of the dissolved partnership is not continue consists in reducing the property to cash and distributing the proceeds. The property must be liquidated and distributed to those entitled thereto. Partners have the implied authority to sell partnership property and to collect obligations due to the partnership. These powers may be delegated to one or more of their number as liquidating partner or partners. And next, rules in settling accounts between partners after dissolution. Number 1, assets of partnership. They are partnership property and contribution of the partners necessary for the payment of all liabilities. Number 2, order of application of the assets. The partnership assets shall be applied to the satisfaction of the liabilities of the partnership in the following order. First, those owing to partnership creditors, and second, those owing to partners other than for capital and profits such as loans given by the partners or advances for business expenses. Third, those owing for the return of the capital contributed by the partners, and finally the share of the profits, if any, due to each partner. Number 2, right of a partner where assets insufficient. If the assets enumerated in number 1 are insufficient, the deficit is a capital loss which requires contribution like any other loss. Next, liability of deceased partner's individual property. The individual property of a deceased partner shall be liable for his share of the contributions necessary to satisfy the liabilities of the partnership incurred while he was a partner. Next, the priority to payment of partnership creditors and partners' creditors. When partnership property and the individual properties of the partners are in possession of the court for distribution, partnership creditors shall first be paid from partnership property and separate creditors from the individual properties of the partners. Next, distribution of property of insolvent partner. If a partner is insolvent, his individual property shall be distributed as first to those owing to his separate creditors, then to those owing to partnership creditors, and lastly to those owing to partners by way of contributions. And next reporter, please.
Let's discuss the following cases. Creditors of the dissolved partnership are also creditors of the person or partnership continuing the business under Article 1840. The first one is when any new partner is admitted into an existing partnership, or when any partner retires or assign, or the representative of the deceased partner assign his rights in partnership property to two or more of the partners, or to one or more of the partner and one or more third persons, if the business is continued without liquidation of partnership affairs. Second is when all but one partner retain and assign their contract and assign their rights in partnership property to the remaining partner, who continues the business without liquidation of partnership affair, either alone or with others. All partners can retain and assign their rights in partnership property as long as there is at least one partner can continue the business and be liable of the dissolved partnership. Third is when any partner retires and dies and the business of the dissolved partnership is continued as set forth up above mentioned of this article with the consent of retired partners or the representative of the deceased partner, but without any assignment of his rights in the partnership property. Fourth is when all partner or the representative assign their rights in the partnership property to one or more third person who promises to pay the debt of the dissolved partnership. The business with the dissolved partnership can continue if the assigned third person is willing to be liable. Fifth one is when any partner wrongfully causes a dissolution and the remaining partners continue the business under the provision of Article 1837, which is when the dissolution is caused in any way, except in the contravention of the partnership agreement, each partner as against his co-partners and all person claiming to them is in respect of their interest in the partnership, unless otherwise agreed, either alone or with others, and without liquidation of any partnership affairs. The last one is when the partnership when the partner is expelled and the remaining partners continued the business either alone or with others and without liquidation of the partnership affair. The liability of third person becoming a partner in the partnership and continuing the business under this article shall be satisfied out of the partnership property only, unless there is a stipulation to the contrary. When the business of partnership after dissolution is continued under any condition set forth in this article, the creditors of the dissolved partnership as against separate creditors of the retiring or deceased partner or the representative of the deceased partner have a prior right to any claim of the retired partner or the representative of the deceased partner against the person or partnership continuing the business. On account of the retired or deceased partner's interest in the dissolved partnership, or on account of any consideration promised for such interest or for his right in partnership property. Nothing in this article shall be construed to the limit of a creditor's right to reject an assignment based on fraud. The use of the partnership name or the name of a deceased partner as part of it by the person or partnership continuing the business shall not make the individual property of the deceased partner liable for any debts contracted by such a person or partnership. Let's proceed to the dissolution of a partnership by change in member. The change in the relation of the partners result in dissolution of the partnership. It may take place when a new partner is admitted, or when a partner retires or dies or withdraw. or withdraws or is expelled from partnership, or when the other partner assign their rights to the sole remaining partner, or when all the partners assign their rights in partnership property to the third persons. Any change in memberships dissolves a partnership and create new partners. How about the rights of creditors and the dissolved partnership, which is continued? Under Article 1840, the rights of creditors and dissolved partnership, which is continued, deals with the rights of creditors when the partnership is dissolved by the change of membership and its business is continued under Article 1837 by a former partner, either alone or with others and without liquidation of partnership affairs. In such case, the law makes the creditors of the dissolved partnership also creditors of the persons or partnership continuing the business. In other words, both classes of creditors, the old or the new one, are treated alike, being given equal rights in partnership property, and it's said by the law. The purpose of the law is to maintain the preferential rights of the old creditors to the partnership property as against the separate creditors of partners. The law highlights the fairness and equality between old and the new one. We have two liability of person contributing business of dissolved partnership. The first one is the liability of the new or incoming partner shall be satisfied out of the partnership property only unless there is a stipulation to the contrary. The contribution of the new partner or incoming business partner to a dissolved partnership must only satisfy the partnership property. Second is, it is applies only when the third person promises to pay the debts of the partnership. Otherwise, creditors of the dissolved partnership have no claim on the partnership continuing the business or its property unless the assignment can be set aside as a fraud on creditors. Under Article 1841, when any partner retires or dies, the business is continued under the condition of outlined in the preceding article or in Article 1837 without any settlement of accounts as between him or his state and the person or partnership continuing the business, unless otherwise agreed or he or his legal representative as against such person or partnership may. First one is they may have the value of his interest at the date of dissolution ascertained. And the second one is they shall receive as an ordinary creditor an amount equal to the value of his interest in the dissolved partnership with attraction, provided that the creditors of the dissolved partnership as against the separate creditors or the representative of the retired or deceased partner shall have prior on any claim arising under this article as provided by Article 1814, which we discussed earlier. If the surviving partners continue the partnership business without the consent of the deceased partner's estate, they do so without any risk to the estate. If the estate consent to the continuation of the business, it in effect become a new partner and would be answerable for all debts and losses arising after the death of the deceased partner, but only to the extent of the descendants' shares in the partnership assets. There are two partners' right to account of his interest. The first one is accrual of right. It is the right to demand an accounting of the value of his interest accrues to any partner or his legal representative after dissolution in the absence of an agreement to the contrary. Partner has the right to know the flows of his interest after the dissolution of the contract agreement. Second is the person liable to render an account. It is the right of a partner or the one who represents him as an owner of his interest to an account, such as a statement of the partnership affairs, and in due course of liquidation, to a payment of the amount of his interest, any be exercised as against first winding up partner, which is the one who conclude all unfinished business pending at the date of dissolution and payment of debts. Second is surviving partner or survivor partner, which is the remaining partner in the partnership. The third is the person or partnership continuing the business. Under Article 1842, the right to an account of his interest shall accrue to any partner or his legal representative as against the winding up partners or the surviving partners or the person of partnership continuing the business at the date of dissolution in the absence of any agreement to the contrary. For the last topic is when liquidation is not required. As a general rule, when a partnership is dissolved, a partner or his legal representative is entitled to the payment of what may be due after a liquidation. But no liquidation is necessary when there is already a settlement or an arrangement as to what he shall receive. As it said, the partner will be liable for obligation in the dissolved partnership or his legal representative will carry out the obligation. And that's a presentation of Group 1, covering Chapter 3, which is dissolution and winding up. Thank you for listening and have a nice day, everyone.